Morning. This is POPS from Legal Reform. POPS is just an acronym for protecting our peoples. Okay, if you've seen any of my other videos, I speak about how I'm adamant about the law and living up to it, word for word, to the letter. This is what creates due process. This is what gives you a fair trial. This is what gives you effective assistance of counsel, the rules of professional conduct, and the code of judicial conduct. So I made a little thing on my Facebook legal reform account. Maybe this will help. So the woman, if I tell the judge to cite my lawyer for ineffective assistance of counsel, my lawyer loses their license. Yes, the judge is supposed to make every lawyer abide by the rules of professional conduct. The Sixth Amendment guarantees you the right to effective assistance of counsel. What if the judge doesn't report my lawyer for ineffective assistance of counsel? Reporting misconduct is mandatory according to the Code of Judicial Conduct as well as the rules of professional conduct. So what happens to the lawyer on the other side? Do they win? No, they are supposed to report your lawyer and the judge. Failure to report misconduct is misconduct. Nobody abides by the rules of professional conduct or the Code of Judicial Conduct. That's why the U.S. Supreme Court doesn't abide. That's why the U.S. Supreme Court doesn't have to abide by the Code of Judicial Conduct. So judges granted U.S. Supreme Court qualified immunity? Yes, exactly. That way they don't have to remove any judge from the bench. By the way, qualified immunity was quashed by establishing the rule of law. And if you look up the Magna Carta, that will tell you. The Magna Carta is the history of the rule of law, originally called the Barons' War, or the Great Charter. And it was created for many reasons, but the main reason was because the king was above the law. No laws accounted. The king could do anything he wanted. The king and his royal court, whether it be dukes, duchesses, the queens, the prince, the queen, they were all above the law, but the king was above the law, utmost, and he held laws against everybody else below him, and so on and so forth. But the common folk you could get arrested. They could make up a law on the spot, which some public servants still happen to do, and then you get charged accordingly. So the judge granted the U.S. Supreme Court qualified. So judges granted the U.S. Supreme Court qualified immunity. Yes, exactly. That's why they don't. That way they don't have to remove any judge from the bench. By the way, qualified immunity was quashed, establishing the rule of law. That's crazy because the U.S. Supreme Court has no code of conduct. Like all the other judges do. But the Supreme Court doesn't have it. The way they worked it out is, like let's say you lose, you win your case in the state court, and they appeal it to the U.S. Supreme Court, and the U.S. Supreme Court they don't go by the laws. They just go by their thoughts and feelings, and they're also I don't know if you ever noticed, all judges are labeled conservative, I think Democrat, liberal. But if you read the Code of Judicial Conduct, all judges are legally required to be apolitical. So anything for political reasons cannot be brought forth in court. Like Roe versus Wade, that was to garnish votes. It was a political thing. In the Code of the Rules of Professional Conduct, it states that nobody can bring forth any case. It's in the interest of the bar. They cannot make any case or decide any case. It's the interest of the bar or of parochial interests. It's in the preamble of the Rules of Professional Conduct. And judges are lawyers before they're judges, so they know this is canon, this is law. They cannot change that, but they constantly do. But the only reason the U.S. Supreme Court doesn't have any code of judicial conduct is so when when whoever you're up against loses in state court, by the time he gets up to Supreme Court, could take an awful long time. But if you check on a quick and speedy trial, there's limitations on that, and they will say that's only in criminal court. But if you read the Rules of Professional Conduct, expediting litigation is mandatory, diligence is mandatory. And there's so many reasons in the Rules of Professional Conduct to tell you why you should have a quick and speedy trial. In the preamble, it tells you procrastination is illegal. And they still do it. Okay, but this is one of my posts. It says, now imagine if everyone walked into court and told the judge to do their job. I'm sorry, it's kind of tiny, I can't see. Now imagine if everyone went into court and told their judge to cite all the violations of the Rules of Professional Conduct. Then every lawyer would have to cite every judge for violating the Code of Judicial Conduct. Let me read that again. Well, imagine if every person walked into court and told the judge to do their job and cite all the violations of the Rules of Professional Conduct, then every lawyer would have to cite judge for violating the Code of Judicial Conduct. It would be like going to the Super Bowl and the other team didn't show up. A huge win for your team because the other team was disqualified for cheating. Okay, so it's not that hard. If it's true, if you go into court, you have to take the rules with you because you're going to have to cite them. People yell at me, why do I got to do this if they know that's their job? But see, they know you don't know what their job, specifics are, Your job, you have details to your job. And if you don't do that job, your job description, you get fired. Now, the Rules of Professional Conduct and the Code of Judicial Conduct are judge and lawyers' job descriptions. They don't do that. That's automatic disqualification. That's ineffective assistance of counsel. And if you read the Rules of Professional Conduct and Code of Judicial Conduct, you'll find out that's not happening. Okay, this is just one of the posts from my page, Legal Reform. I just try to get people interested in as many laws as possible, because you're never going to obtain a fair trial if you don't have effective assistance of counsel. Okay, and the guidelines, the rules for effective assistance of counsel are called the rules of professional conduct. Okay, that's the only way you're going to get effective assistance of counsel. And if you don't know the rules of professional conduct, there's no way your lawyer is going to do it. So look it up. If you got a lawyer, ask them. Even if you don't have a lawyer, find one and question them. I had somebody get mad because they said they knew somebody, a good friend, a brother or sister, a loved one, somebody that was a lawyer, or, and somebody that had family that were lawyers or judges. And I would know, they would tell me. Well, they never bothered to read the Rules of Professional Conduct or the Code of Judicial Conduct. Okay, this is mandatory in every court, no matter what court you're in: child custody, civil court, criminal court, state court, federal court. No matter what court, the Rules of Professional Conduct and the Code of Judicial Conduct are mandatory in every court. Okay? And if you're looking for another state, just put it in another state. Even in another country. Somebody in the UK asked me if I knew anything, and I didn't, so I typed in Rules of Professional Conduct UK, and it gave me the answer, and I went over it with this person from the UK, and then I added a complaint form after that, typed it in. You got the complaint form. I did the same thing in Australia. They don't have lawyers, they have barristers. And so I found that form. I just typed in Rules of Professional Conduct, Australia. Code of Judicial Conduct, Australia. And India too. I don't know, about 8-10 years ago, there was something going on in India. I was reading on the internet, and somebody from India mentioned something. So I typed in the Rules of Professional Conduct, India. And then, the rules for their court system came up, and I gave them the link to it. And person thought I was pretty smart, I just found that out by happenstance, okay? It was just a mere coincidence. But see, AI is in its infancy, so it doesn't know any better, so it's just going to give you variable possibilities of what you could be talking about. And you could come up with answers to questions you haven't even asked, okay? Thank you for listening. This is Pops at Legal Reform. Have a good day. God bless.